Hi, everyone. Thanks so much for coming out. Appreciate it. We're going to go ahead and get started. A few scribers will come in. I'm Dr. Damian Arthur, the Distinguished Scholar and Director of the Center for Consumer Law and Education, who is presenting this talk today with Casey Baker here. Just tell you a little bit about the center. We are newly founded last year with a very generous donation from David Romano, a lawyer in Clarksburg, and essentially he wanted a think tank of sorts to deal with consumer law in the state of West Virginia. And so he basically has willed this into existence. He donated $2 million. $1 million of it went to WVU College of Law. The other half of the donation came here to Marshall University. And so he basically said, here's this money, create something that's really great. And naturally, they picked me to do it. That was a joke. But myself and my counterpart at WVU, Jonathan Marshall, who couldn't be here today, he's in Miami. Yeah, I know, right? Poor him. But he's in Miami on business. But we have worked a lot over the last year to kind of formulate what it is that we're trying to do, what our mission is, what our goals will be for the year. And so we have essentially come up with what we think would be the best approach for this in the state of West Virginia and nationally. And so I'm not going to read the mission and the vision to you. You can go to our website and do that. It's I'll show it to you, but it's theCCLE.org. A lot of it's up there. I'm going to embarrass my GA Anthony and say that essentially the website, I mean, everything. He's done literally everything on it. It looks phenomenal. He's built it from the ground up with in terms of design and the help with Brian Morgan in the computer science department. And so, yeah. He really has done a great job. As an accounting major, it's kind of impressive that he's able to do but aside from that, I mean, we do aim to be the leading consumer law education center. There are only a few of these in the nation. Berkeley has one. I think there's one in Minnesota. There's one in Houston, and now we have one. And so a couple of different things that we're going to be doing. One is what we call the People's Law School, and that will essentially be providing lectures and topics and information and research on things of interest to students, to faculty, to the public across the state. And so this is why we're going to have this talk on bankruptcy, because that's a very important topic right now, particularly for student loans. And so, but without further ado, we'll talk more about the center in a little bit. But I'm going to introduce Casey here, and he's a tri-state native and a lifelong resident of Proctorville. He graduated from Ohio University with a BBA in 2005, and Ohio State University's Moritz College of Law with a JD in 2008. Good school. He's had an active law practice since 2008, starting at Huddleston, Bolin, now Dinsmore. I guess that's important. In Huntington, where he became the senior transactional law associate. He practices there representing banks and credit unions in collection cases, and as well as Chapter 7 bankruptcy trustees. Among other work, he did lots with the coal companies, real estate, and various small businesses. In 2014, he joined a smaller firm, Myers and Neville in Chesapeake, as a partner, and he shifted his practice more to the consumer and individual side of transactional law, with a healthy estates, probate, and real estate practice. He's taught business and consumer law topics at the university level since 2009, first as an adjunct faculty at Ohio University, and then as full-time faculty and member here at Marshall. So let's give him a hand. And
Thank you. When I do talks like this, I have a couple rules. First of all, you're allowed to ask me any question you want to ask me, so long as I'm allowed to answer, I don't know. People say, well, you're a lawyer, you ought to know that. Well, no. There's a lot of law out there, and we're just barely scratching the surface, just on one specific topic today, bankruptcy law. So you're free to ask me whatever question you want to. But if I don't know the answer, I reserve the right to say I don't know. I don't want to give you wrong information. I don't want to give you bad information. Second ground rule, and this isn't my rule, this is the Ohio Supreme Court's rule. I'm a practicing attorney in both West Virginia and Ohio, and we have these things called ethics rules. And one of the ethics rules that attorneys are under involves in-person solicitation of business. We're not allowed to personally solicit legal representation in talks like this, is the way Ohio has construed their rule very broadly. So if you ask me a question, it has to be a hypothetical. That hypothetical can be identical to your personal situation, okay? But your question has to be a hypothetical, and I will answer your hypothetical question to the best I can. If I can't, again, I reserve the right to say I don't know. So those are my two ground rules for any questions you may ask me, okay? We good? All right, and we will have, we are scheduled to go till 5 today. I know several of my students have said that they have to leave because they have class at 4. That's fine. If we're here till 5, something has gone terribly wrong. But there will be an opportunity for questions. Should be plenty of time for questions if anybody has any at the end. Today's lecture, and I do want to thank Damien. This is the first lecture you guys have had, right? Yes. So I feel special. I'm the leadoff hitter, so that means something. I guess I can't, I haven't set the bar, or nobody set the bar yet, so I can't underperform, right? But anyway, today's lecture is titled "I Declare Bankruptcy," and if you don't know what that is a reference to, it's to one of the greatest television shows of all time, The Office, and we'll play the clip. Maybe.
Declare bankruptcy, all your problems go away. Creed Bratton has never declared bankruptcy. When Creed Bratton gets in trouble, he transfers his debt to William Charles Schneider.
Oh, the hell, Creed? Monopoly, you go bankrupt, please.
You don't play Monopoly, man. That game is nuts. Nobody just picks up get-out-of-jail-free cards. The things cost thousands. That's a good point. Bankruptcy, Michael, is nature's do-over. It's a fresh start. It's a clean slate.
Like a witness protection program.
Not at all.
I've always wanted to be in a witness protection program. Fresh start. No debts, no baggage. I've already got my name picked out. Lord Rupert Everton. I'm a shipping merchant who raises fancy dogs. That's the life. I declare bankruptcy!
There's a second part to the clip. I don't know why that one doesn't have the whole thing. But
I declare bankruptcy!
Hey, I just wanted you to know that you can't just say the word bankruptcy and expect anything to happen.
I didn't say it, I declared it.
still. And funny story about that. I'm terrible at coming up with titles. So I told Damien, just you come up with something. Just make it exciting. And I already planned on opening up with Michael Scott. And that was the title he came up with, was I Declare Bankruptcy. So I was like, okay, I'm vindicated. I'm okay. It's okay to lead off.
I drink like 100 iced macchiatos a day and fast.
Okay, so I declare bankruptcy. Yet, it might not be the solution to the consumer's financial problems. Okay? What do we mean by that? Well, I'm going to start with a little bit of background information where I come from, how I come at this issue. And Damien went through some of this already. I've been teaching this stuff since 2009, for a decade now. Various business law, consumer law related issues. I've also got a research paper that's in publication right now, looking at bankruptcy, filing rates, and wage garnishments. And do we see any kind of variation among the states, any kind of trend among the states based on what they're wage garnishment laws are with regards to bankruptcy rates. And then maybe most relevant for consumer law is my law practice. I've been an active practicing attorney since 2008. Probably the first half of my career, I was very heavily involved representing creditors, mostly banks, community banks, and credit unions, but a few national banks as well, in bankruptcy proceedings. I also did some work with Chapter 7 bankruptcy trustees, which we'll talk about what a Chapter 7 bankruptcy trustee is here in a minute, which is a unique experience, and I'll talk about why. In 2014, I decided I've had enough of the big corporate world, corporate law life, and decided to go to a little bit smaller of a firm with more individual consumer type clients. And I've represented several consumer debtors, never in bankruptcy, because usually we can sit down, plot out the client's goals, and figure out, you know what, maybe bankruptcy isn't the best option here. We've got other ways we can protect you without running you through a bankruptcy. Because when you go through bankruptcy, there are a lot of nasty side effects that can stick with you for a while. So if we can avoid those nasty side effects, we're going to. So what is bankruptcy? What is bankruptcy, other than something we can declare or, the end of the game in Monopoly, as Michael Scott mentioned? Well, bankruptcy is essentially a section of the federal law, and it's an entire code. There's an entire book. I can't remember exactly how many volumes of federal law there are, 50 some, and this is one entirely. But basically it allows insolvent debtors to escape the legal obligation to pay debts, to pay claims. Claims is probably the better word there, but I'm gonna. A bankruptcy attorney would say, no, it's not a debt, it's a claim. A claim is broader than a debt, and that's true, but raise your hand if you're a lawyer. Okay, good. So I'm going to say debts. So a couple things to unpack here. Insolvency. To be eligible for bankruptcy, you must be insolvent. What does that mean? Anybody know? Well, there's two ways you can be deemed insolvent. The first is what we call balance sheet insolvent. Balance sheet insolvent means you owe more than you have. Your debts exceed your assets. Accounting students in the room, what does that usually mean? Assets equals what? Liabilities plus equity, right? So negative equity, if you want to think about it in terms of a balance sheet. The other way you can be insolvent is what we call cash flow insolvent. Cash flow insolvent means you can't pay your bills as they come due. Maybe you have enough stuff there, maybe your stuff, total value of your stuff, exceeds your debts, but you're just in a short-term cash crunch and you can't pay your bills right now. That's still insolvency. That's still an insolvent individual. The other thing to keep in mind here is a legal obligation. We say you can escape the legal obligation to pay debts. What we mean by that is that it's not that the debt goes away after bankruptcy. The debt's still there, but the creditor can't collect it. They can't attempt to collect it. Well, I'll put it that way. You can voluntarily pay it if you're the debtor, and we'll talk about maybe why you'd want to do that. But the creditor can't chase the debtor down. So, why? Why just allow people to walk away from their debts? Well, you've got two guiding principles in any consumer bankruptcy. It's a little bit different in a business bankruptcy. You don't have the first of these principles. But in a consumer bankruptcy, you have two competing principles that you're trying to achieve. The first is what we call the fresh start principle. That was the one thing Michael Scott got right. Well, and he didn't really get it right, but he at least used the right word, right? A fresh start. Sometimes bad things happen to good people. Sometimes circumstances just happen. And we don't want to hold those things over people's heads all the time. Sometimes people get sick and they have medical bills. Sometimes people get into car accidents and, they have medical bills from that. Sometimes People lose their jobs, and now all of a sudden they can't afford their mortgage. So bad things happen to good people, and we're not going to punish them for the rest of their life for poor circumstances. So bankruptcy really is supposed to be a reset button. You file bankruptcy, you have that fresh start. From the moment you file the bankruptcy, it's supposed to be a new financial lease on life. The other principle is what we call equitable distribution. Equitable distribution. Basically, the idea here is creditors have rights too. Yeah, you want a reset button, but we have to understand that creditors aren't going to lend money if all a debtor has to do is file bankruptcy to get out of it. I mean, would you loan somebody money if you knew all they had to do was go to the courthouse, file a bankruptcy petition, and boom, they don't owe you anything anymore? You have zero ability to recover anything. Would you loan money? I wouldn't. So you have these two competing goals. On the one hand, we want to give consumers a fresh start. On the other hand, we want to make sure that creditors are treated fairly in the bankruptcy process. What this means is, because we have these two competing principles, bankruptcy is complicated. It is very difficult for even many attorneys to understand some of these unique concepts. You don't dabble in bankruptcy law. If you're going to practice bankruptcy law, that needs to be a healthy portion of your law practice. So as consumers, I'm advising you, don't go to your divorce attorney for a bankruptcy. Don't go to your personal injury attorney for a bankruptcy. You need to go to a bankrupt your case, if that is something you want to pursue. For our conversation today, I did want to go over a couple key concepts that will help explain why bankruptcy is complicated and why the consumer may not get the relief they think they're going to get. The first is what we call, well, the first is just general procedure. What are the parts of the bankruptcy that a consumer debtor needs to understand? Number two, types of debt. Different types of debt are treated differently under the bankruptcy laws, and we'll talk about some of those different types of debt. The third, exemptions. What can't the bankruptcy touch? What do you get to keep? What stuff do you get to keep regardless of the fact that you filed bankruptcy? That's what we call exemptions. So let's get into that. Procedural. If you want to, quote unquote, declare bankruptcy, again, you don't stand up there and yell bankruptcy. You file what is called a petition. The petition is it's a formal pleading that begins the bankruptcy process. The petition is key. The petition date, and it's the moment that bankruptcy petition is stamped filed. That filing moment is the cutoff, your financial cutoff as a consumer. Everything before that petition is subject to bankruptcy. Everything after that petition is yours, be it debt or asset. Okay, so petition, very important. With that petition, you will file schedules. Schedules list your assets, your sources of income, your debts, the creditors who you owe those debts to. I don't have that on there. I don't know why I didn't put that on there. But you have to identify all these people and all these things that you have and all this money you owe. These schedules can get pretty voluminous. I mean, you can go on for a couple hundred pages with all these different schedules if you've got a fairly complicated consumer bankruptcy. Another very, very, very important bankruptcy concept is the automatic stay. The automatic stay kicks in at the moment that petition is filed. And what the automatic stay says is, for most creditors, there are some exceptions, child support's an exception, criminal prosecution is an exception, but for most creditors, most civil actions, most court actions against the debtor are stopped. They're put on hold until the bankruptcy case can resolve itself. Okay? What this is meant to do is give the the debtor some breathing room. Stop all those collection attempts, give the debtor a chance to get on their feet while the bankruptcy is pending, and get started with that fresh start. The last procedural concept is known as a discharge. Discharge kind of sort of serves the same purpose as the automatic stay, but it's after the bankruptcy is in. At the end of the bankruptcy, the automatic stay goes away and the discharge kicks in. And again, most consumer debts at the end of the bankruptcy are uncollectible. Not that the debt goes away, but the debt is uncollectible as a result of the discharge. So let's talk about different types of debt. We've got three different categories I want to talk about. The first is secured debt versus unsecured debt. Secured debt is debt for which there is collateral. So a home mortgage. The debt is the loan that you borrow to buy your house, or home equity loan or whatever. The collateral is your home. That's secured debt. Auto loans usually are secured loans. There's collateral for it. Your car. If you don't make the payments, what happens to your car? Gets repoed, right? Repossessed. The tow truck comes along and hauls it away, if they can find it. I've never done that. Priority debt versus non-priority debt. This has to do with that equitable distribution principle. The bankruptcy code basically provides the order that debts get paid. So the first thing that gets paid out of the bankruptcy are domestic support obligations, child support, spousal support. That gets paid before lawyers get paid. Since lawyers write the law, usually we prefer ourselves when these things get written, but that's okay. We get paid next. That's the administrative expenses. Those are the cost directly associated with the actual carrying on of the bankruptcy. So that would include court costs, it include attorney's fees. If you have to sell property, it would include the realtor's fee. The bankruptcy trustee, which we'll talk about in a second, collects a fee. Those are all administrative expenses, but it's directly incurred as a result of the bankruptcy itself. Expenses that would not have existed had there not been a bankruptcy. Might be a better way to say it. Third is taxes. You got to pay your taxes in bankruptcy. Notice the lawyers get paid before the government, but the government gets paid before almost everybody else, right? Fourth, DUI personal injury claims, interestingly, have a weird priority perspective. Somebody's been able to go in there and successfully lobby, probably lawyers. Plaintiff's bar has been able to go in and successfully lobby Congress to stick DUI personal injury claims in there, ahead of what we call general unsecured claims. General unsecured claims, well, they're unsecured, first of all, right? So that means there's no collateral. And then they're general, which means that it's something that's not otherwise covered by the non-priority or by the priority list. So those get paid last. Usually that's credit cards. We'll talk about general unsecured claims in a second. All right. Third distinction that we have to understand in bankruptcy is dischargeable debt versus non-dischargeable debt. Remember I talked about the discharge. At the end of the bankruptcy, most debts are no longer payable. They're no longer legally enforceable. But some are. Some remain legally enforceable. So that means there are some debts you can't get rid of via bankruptcy, including taxes. So not only do taxes get paid as a priority claim, if there's not even enough money to pay your back taxes, you still have to pay them once you emerge from bankruptcy. You can't get rid of taxes in bankruptcy. Fraud, if a claim, a debt exists because the consumer debtor defrauded someone, that does not get discharged. Intentional torts. So you get into a fist fight with somebody and you break their face and have sued you. That doesn't go away. Does not go away. Domestic support obligations, again. Still got to pay your child support, even after bankruptcy. Criminal fines. So again, you get that, not only do you have to pay the DUI personal injury claim, but you also have to pay the DUI criminal fine. You can't get rid of that in bankruptcy. DUI personal injury verdicts. And student loans. Student loans are not dischargeable in bankruptcy, usually. We'll talk about when they might be here in a minute. But any questions on the different types of debt in bankruptcy? Secured versus unsecured, priority versus non-priority, dischargeable versus non-dischargeable. Those are the key distinctions. So if most of your debt is non-dischargeable, does it make any sense to file bankruptcy? No, not at all, right? So if your primary debt is a whole bunch of taxes you owe, well, what's the point of bankruptcy? You're not going to get anywhere. We have other ways we can sort that out. Okay, so now let's talk about assets. This is where the exemptions kick in. Exemptions basically are laws that say consumers are allowed to keep certain assets free from bankruptcy, free from creditors, up to a certain dollar amount. Now, if you have equity, so if, say, the value of the asset exceeds the amount of the exemption, you might have to buy that equity from the bankruptcy to keep the asset. So let's say you have a $5,000 car and the exemption is $2,000. If you want to keep your car, what do you have to do? Car's worth $5,000, the exemption is $2,000. What do you got to do? Right, you either pay $3,000 to keep the car, or you sell the car for $5,000 and keep $2,000 of it. Either way, the bankruptcy has $3,000 to pay general unsecured claims. Okay? Different asset classes have different values. So, I mentioned cars. You will have homes will have a certain exemption amount. Cash or bank accounts will have a certain exemption amount. You can keep so much cash. Tools are one. So, a lot of people need their tools to work. So we allow exemptions for tools. Wages, wage garnishment exemptions is something out there. Those are important. We'll talk about how they may impact the bankruptcy here in a minute. But unless you are cash flow insolvent, wages don't matter that much, because anything you earn after the bankruptcy petition is filed is yours anyway. You get to keep all that. It's only when you might file a payment plan, which we'll talk about in a second, that wage garnishment seems to matter. State-by-state rules, that's the other key concept here. Every state is a little bit different in what their exemptions are. So you have to look at the state where you live when you file the petition. And that's mostly true. Every now and then, if you have somebody who will move from state to state, you might have to look back to their former state. That's very technical. Just so if you want to file bankruptcy, if you're thinking about filing bankruptcy and you've recently moved from another state, just make sure you mention that to your attorney. Because if they screw it up, then you have a malpractice claim against them. And that's nice. Okay, yeah, so not all states treat assets the same. I have a Florida homestead exemption up there. Anybody know what the Florida homestead exemption? How much of your personal residence, up to what dollar amount in Florida, can you keep free and clear from bankruptcy? Anybody know? All of it. It's an unlimited exemption. You can have a $30 million home that you own free and clear. And if you're cash flow insolvent, you can file bankruptcy, keep your $30 million home, and there's not a thing your creditors can do to touch it.
So does that mean the creditors down there are more liable for when they're issuing like home loans?
Yeah. I mean, Florida's got a host of other risks that go with it. Hurricanes, for instance. But yeah, mortgage lending in Florida is a little bit more of a gamble than it is in a place like West Virginia. For that reason. West Virginia's exemption, I want to say, is 25,000. Off the top of my head. I should know that. No, I do know that. Yeah, it's 25,000. So again, big difference. Ohio's is 125,000. So even, a big difference between Ohio and West Virginia.
But you couldn't just pop down there and say I want to buy a Florida house.
No. That's that rule where if you move, and I want to say it's like 2 years, if you've moved within 2 years, you have to apply the homestead exemption of the state where you previously lived. Because I've actually argued that case. Had a Florida resident move to West Virginia and say, well, since we lived in Florida 2 years ago, we want to claim the Florida homestead. And I beat that on behalf of a creditor saying, well, look, no, the Florida homestead only applies to Florida residents. You're no longer a Florida resident because you now live in West Virginia. And the court agreed. So, hey, we got to take their home. For the benefit of the general unsecured creditors. Okay, an important note on exemptions. They do not apply to secured debts. They do not apply to secured debts. What do I mean by that? Here's an example. Let's say we have a Cabell County home valued at $100,000. There's a mortgage loan on the property for $80,000. The West Virginia exemption for residences is $25,000. See, I knew that. So how much equity does the homeowner have in their home? Equity being asset minus liability, right? Asset minus liability here is $20,000, right? Okay. That's what I just said. $20,000 of equity in the home. And the exemption is $25,000. So if this individual were to file bankruptcy, the trustee, we'll talk about in a second, or general unsecured creditors could not force the debtor to buy any of that equity, or they couldn't force the debtor to sell that home. But, that mortgage is still $80,000 because it's a secured debt. The unused $5,000 doesn't knock that $80,000 mortgage down to $75,000, okay? It's still an $80,000 mortgage. If the debtor does not pay the mortgage balance, $80,000, the creditor can still foreclose on that home, okay? So again, this is another thing we got to look at when we're trying to figure out, will bankruptcy actually solve your problem? If you want to keep your home and you can't make your monthly payment, but hey, I've got all this equity in my home, my exemption will knock it down. Doesn't really work that way. All right, now let's talk about the trustee. Who is the bankruptcy trustee? Bankruptcy trustee is an independent party, usually an attorney. Every now and then you'll get a non-attorney serving as a bankruptcy trustee. I represented a CPA who did a lot of bankruptcy trustee work once. But basically the trustee's job is to make sure that creditors' claims, the money owed to creditors, is paid in accordance with bankruptcy law. So, kind of a referee. You've got the judge who's a referee, but then you've also got the bankruptcy trustee just trying to make sure everybody's playing by the rules. That being said, the trustee works with debtors and creditors, not for debtors and creditors, okay? Between the two, debtors or creditors, actually the trustee probably has an incentive to favor creditors, general unsecured creditors, because the amount of money that the trustee makes off a bankruptcy case is set by a schedule, and that schedule is based on how many general unsecured creditors get paid, how much they get paid. So more assets, more claims get paid, the more the bankruptcy trustee makes. So if anything, probably err on the side of paying more creditors, keeping them from objecting to something like that. So what's a trustee do? The trustee looks at the petition, the schedules, exemptions, and figures out what assets are out there. And that's because the trustee technically owns, at a minimum controls, but technically owns all of the debtor's non-exempt assets while the bankruptcy is pending. So that's why the bankruptcy trustee can force you to pay or force you to sell your $5,000 car. Because technically the trustee owns that while the bankruptcy is pending. If you don't want to buy the equity, the trustee can say, well, fine, we're going to sell it. I want my $3,000. Either you pay me the $3,000 debtor, or we'll sell it on the open market and I'll get my $3,000 that way. The other thing, though, the trustee can ask the bankruptcy court to deny the discharge if the trustee thinks that the debtor has not followed the rule. If we've omitted something from our schedules that the trustee thinks is material, if we've lied on our schedules, if we've committed perjury, and that happens every now and then, somebody will get it under oath and lie about what they have. Trustee can ask that the discharge be denied. And again, that defeats the entire purpose of the bankruptcy, right? You now have this bankruptcy on your credit, but you don't have a discharge. That's a problem. So, how do we know? Is a bankruptcy a good idea? Well, I've got 3 questions probably worth asking. And if you're a consumer looking to file bankruptcy and you meet with an attorney, you should make sure these 3 questions are answered. First, what are the consumer's post-bankruptcy financial goals? How much of your stuff do you want to keep? What's your job prospects? What are these lingering debts out there that might persist, that impact that financial outlook? These are all things you got to keep in mind because there's a before bankruptcy and an after bankruptcy period. And once that bankruptcy petition's filed, you're stuck. You're set. Everything is pre-bankruptcy or post-bankruptcy. Number 2, will the bankruptcy law actually fix the consumer's financial problems? Maybe it will, maybe it won't. Maybe it'll make it worse. There are times that the bankruptcy actually makes the consumer's financial situation worse. So we got to know, will the bankruptcy actually achieve our financial goals? 3, is there another alternative? Is there a non-bankruptcy law out there? Excuse me. That offers sufficient protection without all the downsides that bankruptcy might cause us to incur. So let's dive into financial goals. Asset and income needs. There are 2 flavors of consumer bankruptcies. Chapter 7 and Chapter 13. Anybody know the difference between Chapter 7 and Chapter 13? There's also a Chapter 11 out there. Here's some people talk about Chapter 11s. Chapter 11s are totally business, though. So we're going to ignore Chapter 11. There's actually a Chapter 12 and a Chapter 15 and 2, but we're not going to worry about those. Chapter 7 and Chapter 13 are your 2 primary consumer bankruptcy procedures. Anybody know the difference? Nobody?
Is it commercial versus individual?
No, that's Chapter 11 versus usually Chapter 7.
Full discharge, partial discharge?
Nope. Good guesses. Good guesses. Anybody else? We'll take one more guess if somebody has it.
How much stuff you get to keep?
Yeah, in a roundabout way. Yes. It's liquidation versus payment plan. And in Chapter 7, the bankruptcy trustee basically gets to say how much of your stuff they're going to make you sell. In a Chapter 13, we give you the opportunity to make payments over time. And so long as you make those payments, you get to keep your stuff. If you don't make your payments, now we get to sell your stuff. Would you prefer to have a bankruptcy trustee sell your stuff, or would you prefer to keep your stuff and make payments over time? Usually. Raise your hand if you'd rather say, no, bankruptcy trustee, you take it all and just sell it. I don't care. Okay. Okay, a couple. Raise your hand if you'd like, no, you know what, I've worked hard to keep my stuff, or to get my stuff. If I can keep it, I want to keep it. Okay, that's usually about right. Most consumers prefer the payment plan, prefer the Chapter 13, because they get to keep their stuff, assuming they can make payments. The catch is with the payment plan, you have to have what's called a regular income. Regular income means you got a steady paying job. If your income fluctuates massively month to month, if if you're, seasonal, you've been gainfully employed for a certain period of time, and off the top of my head, I can't remember what it is, you're not eligible for the Chapter 13, and you have to file the Chapter 7 liquidation. And that was the law up until 2005. In 2005, creditors got together and went to Congress and said, hey, we got a problem. Too many high-income, low-asset consumers are abusing Chapter 7 bankruptcy. Well, wait a second. Everybody wanted to do Chapter 13, right? How would somebody who's high-income, low-asset abuse Chapter 7?
You don't effectively really own anything.
Well, right. Let's say you make $200,000 a year. Would you agree that's high income? Okay. Let's say you spend $150,000 of that every year traveling around the world, dining at five-star restaurants. You can probably rack up $150,000 a year if you're flying to Monaco every weekend, right? Yes. You have terrible spending habits. You have nothing to show for your $200,000 a year, but a lot of, Instagram posts about the great food you've eaten. Okay, and what's an Instagram post worth? Well, for most consumers, nothing. So creditors got together, lobbied Congress, and said, you know what, we think this is a problem. We want you to change the law to prevent this abuse. So we got a law called BAPSIPA, Bankruptcy Abuse Prevention and Consumer Protection Act, which did a whole lot of things. They said, okay, we're going to fix this abuse, and then we're going to do a whole lot of other things too, and really ended the casual bankruptcy. Now you have the just guys who do bankruptcy as attorneys full-time, and then guys who don't, for reasons we won't have to get into today. But basically, in bankruptcy law practice, it's pre-BAPSIPA and post-BAPSIPA. BAPSIPA was that revolutionary when it comes to the actual workings and the rights of consumers in bankruptcy. But for our purposes here, means testing is the key concept. What is means testing? Well, basically, again, this is complicated, very complicated, very, very, very complicated. What we do is we look at how much money you make over 6 months, and we subtract out certain allowances based on your family size, where you live, and that's at the county level even, how many cars you own. Those are all personally tailored to you. And then we have standard allowances for utilities and insurance costs, medical bills, and these are all set by statute. But you got to go through the process of calculating all these things. And it's hard. And because it's hard, people don't like to do it. Because it's easy to screw up. And roundabout conclusion is if you make too much money, BAPSIPA says you're not allowed to file Chapter 7 bankruptcy. You can only file a Chapter 13, which for most people isn't a problem. And that's what the data is actually showing. Maybe like 3% of debtors are actually impacted by this means test. But we have to go through the means test to make sure that they are in fact eligible for Chapter 7. And here's why most debtors are not impacted. This is our three tri-states here locally, West Virginia, Ohio, and Kentucky. If you make less than that per month, you can file Chapter 7. $6,100, almost $6,200 a month in West Virginia. If you're making $6,200 a month in West Virginia, you're doing all right, right? You're doing all right. Not fantastic, not great, but you should be able to survive on $6,200 a month. I hope. If not, again, if you're flying to Monaco every weekend, maybe you can. But anyway, most debtors are well within that safe harbor. So means testing is a scary thing, it's a complicated thing, it's a confusing thing, but at the end of the day, it doesn't matter for most debtors. Now, let's move on to the next question. Will bankruptcy actually fix your problem? Will bankruptcy make your life easier? Will it get rid of these debts that are keeping you up at night? Again, only unsecured debt is discharged. Secured debt does not go away. As I mentioned in my example, if you got that $80,000 mortgage out there and you file bankruptcy, even if your house is $100,000 and the equity is exempt, you still have to pay that $80,000 mortgage. The creditor can foreclose on you if you don't make your payments. So examples of unsecured debt, this is usually what we're talking about when we think, okay, is bankruptcy a good idea? These are examples of unsecured debts that usually do get discharged. So we have credit cards. Credit cards is a big one. Credit cards is a real big one. Medical bills. One of the leading causes of consumer bankruptcy are medical bills. As far as I know, they can't repossess your kidney that they've transplanted into you. I don't think that's okay. I don't know of a situation where you can have the medical procedure be secured by a loan. I don't know. Maybe it's out there. I don't know. You get some creative finance guys out there. Maybe they'll figure that out. But usually medical bills we can take care of in bankruptcy. Also, tort and contract judgments. If you've just been sued in a lawsuit and lost and you didn't have insurance to cover the claim, you can get rid of that judgment in bankruptcy. Examples of secured loans that usually bankruptcy will not fix unless you're willing to get rid of your stuff. Home mortgage and auto loans are the two big ones. You can delay collection because that automatic stay will stop collection. But eventually you're going to have to make your payments. Eventually you're going to have to catch back up. And a lot of times once you get behind, consumers have a hard time catching up. Very hard time catching up. Okay, so even if we have unsecured debt that we think might work in a bankruptcy, we have to understand what unsecured debt still isn't dischargeable. Taxes, support obligations are the two big ones. You can't get rid of taxes in bankruptcy. And again, student loans. Student loans, unsecured. Federal direct loans cannot repossess your diploma. Congratulations. However, they can make your life very difficult. There are cases where, middle of the night raids, SWAT teams kicking in people's doors because they haven't made their loan payments. That's been a few years since I saw that story, but I did see that story a few years ago. Now that being said, it is possible if you can show an undue hardship, and that's the term of art, undue hardship, that a bankruptcy court will go ahead and discharge your student loans. Anybody know what it takes to show an undue hardship? There's three things you got to show. Well, number one, you got to show that you have made a good faith attempt to pay your loan. Okay? You've tried. Number two, you have to show that you're making so little money that you can't afford a minimum standard of living. What is a minimum standard of living? That's kind of up to the judge to decide. The third thing you have to show is that your situation isn't going to improve by the time the loan is set to be paid in full. So you've tried to pay it. You literally financially cannot make these payments without, missing meals. And three, odds are you're not going to find a better job and be able to eat. If you can show those three things, the judge may, doesn't have to, but may agree that your student loans are dischargeable. That's hard to do. That is hard to do. So before you borrow your student loans, make sure you can actually find a job that will repay them. Yes?
Aside from access to the credit, what's to prevent folks from getting a credit card and paying their tuition on a credit card?
Will the university accept it? And usually credit card interest rates are way higher than student loan interest rates. I don't know that that would be a wise financial decision.
No, but I mean, you could, theoretically, if you could get access to the credit, fund your 4-year degree and then file bankruptcy because it's an unsecured debt. And it could
No, I don't know that you can do that. I think they might be able to say the loans were for an educational purpose. I'd have to go back and look at the exact language of the statute. But there might be a way for a credit card company to argue that that is still a student loan. That is still a loan for an educational purpose. That's a good question. I haven't looked at that specifically, but I got a feeling the credit card lobby's strong enough that they could shoehorn that into the statute.
And I imagine it'd be difficult to get access to that much credit, but
Well, I don't know.
maybe not.
I've seen people with $30,000 credit card bills who really should not have ever been given a $3,000 credit limit. Oh yeah, you're eligible now for a brand new offer. Okay, I got a personal story. When I bought my house 2 years ago, and when I applied, I instantly, within 15 seconds, got a phone call from the bank where I applied online letting me know that I was eligible for a $750,000 mortgage. And I have no business borrowing $750,000. The bank has no business loaning me $750,000 to buy a home in Proctorville. Because you can count on one hand how many homes in Proctorville were $750,000. And when that happened, that just blew my mind exactly how some of these larger financial institutions just look at the numbers. And if you have a split moment in time where you satisfy the numbers, boom, they'll extend you the credit to you, whether or not you need it. Not good. I got a little, not really a rant, but some insight on that. We'll talk about it in a second. Actually, right here. Even if debt is discharged, it may be a good idea to go ahead and pay it. Why? Why might you want to go ahead and pay that loan even if it is discharged? Unsecured general loan.
Credit score.
It's going to help your credit score a little bit. But I am a huge believer in relationship lending, relationship banking, community banking, credit unions. Find somebody local who you can actually talk to about your situation. Not somebody, 8 states over in a call center just looking at your numbers and saying, here's what we can do for you. Find somebody you can relate to on a personal level and actually have a conversation with them about your situation. Because a lot of times you can work these things out without having to go through a bankruptcy, so long as you have a good relationship with your lender. Might bankruptcy actually make your situation worse? Maybe. There are ways that it can. First of all, you've got your credit score. Bankruptcy is going to stick on your credit report for 10 years. That's longer than the bankruptcy ineligibility period lasts. You can file bankruptcy every 7 years. But it's going to stick on your credit report for 10. What does that mean? You got to fix the underlying problem. You got to fix the reason you wound up in bankruptcy. Bankruptcy is a means to an end. It is not an end unto itself. If you don't fix whatever the situation is. So, if it's you lost your job, okay, you got a couple years here where you've got a window where you can get a better job, go get an education, finish your school, get that degree to enable you to have that higher income. So that way, when you get out of school, you can afford your bills. Or on the flip side, you cut back on some of this extravagant spending maybe you're engaged in. Because, again, you got 7 years before you can file bankruptcy again, and that credit score is going to linger out there. Most people need credit somewhat. Maybe we don't need it as much as we rely on it, but very few people can pay cash for a home. Very few people can pay cash for an automobile. Very few people can pay cash for a vacation. You know what? it's some ungodly percentage of people who, if they needed $1,000 today, if they had an emergency where they needed $1,000, they could not come up with it. It's like, what, 50% or something of Americans? That's scary when you think about how much on the edge there we are. So you got to figure out some way to build that buffer, and you got a limited period of time to do it. If you file bankruptcy and you don't fix that underlying problem, you got a while before you can hit that reset button again. The other thing, this is a fun game lawyers like to play. If you forget to put something on your bankruptcy schedules, this doctrine of estoppel can really mess up your life. Here's an example. Let's say a debtor files bankruptcy due to medical bills resulting from a car accident. Okay, that happens. You get involved in a car accident. You don't have health insurance. So all your medical bills are piling up. You're getting calls from bill collectors. You're tired of dealing with it. You've got chronic pain. You don't want to deal with bill collectors too. We'll just file bankruptcy to take care of it. After the bankruptcy is completed, you get a letter from a personal injury attorney saying, hey, you know what? We saw the police report on this. We're not sure why you haven't filed lawsuit yet, but you've got a real good case against the other driver. They've got $300,000 of liability insurance. And you're sitting there thinking, oh, hey, I can get back up on my feet. That'll help. But here's the catch. That right to sue that other driver is technically an asset of the bankruptcy estate. That means it doesn't belong to you anymore. It belongs to the trustee. And that's the other thing, if you forget to put it on those schedules, which is real easy to do, because when you're thinking of assets, would you naturally think, oh, I've got this right to sue this guy, that's an asset. That's not usually what we think of when we think of assets. We think of tangible things, our cars, our homes, money in the bank. We don't think of these rights to sue, these personal injury claims, as assets, but they are technically. So what this doctrine of estoppel says is, if you forget it to put that personal injury claim, and not just personal injury, any claim, it could be a contractual claim. If you forget to put that on your schedules, after the bankruptcy's over, you want to sue on that? Nope, can't do it. And that's real easy for a defense attorney. I mean, it's a standard question. Have you ever filed a bankruptcy? Yeah, I filed a bankruptcy. Oh, you have? What? Do you remember the case number? No, I don't, but I get it from my attorney, my bankruptcy attorney. Who was your bankruptcy attorney? Oh, John Doe, Huntington, West Virginia. Okay. Subpoena, or you really just pull up the electronic records, because that's all electronic now. You can search by name. Pull up the bankruptcy schedules. Hey, wait a second. This personal injury claim wasn't listed as an asset. Motion to dismiss, granted. Personal injury case will go away. It's almost automatic. So, easy thing to screw up. Very easy thing to screw up. And all of a sudden now you have no ability to sue for your personal injuries. So, is there other law out there that might be better than bankruptcy if we need relief? And yes, there may be. First of all, those state exemptions apply not just in bankruptcy, but outside of bankruptcy as well. I don't have to file bankruptcy to get a benefit of the exemption. That works outside of bankruptcy too. Especially wage garnishment. Now, it said in bankruptcy, wage garnishment, if I'm doing a Chapter 7, wage garnishment doesn't matter that much. Outside of bankruptcy, it's huge though. If you don't make much money, guess what? It might not be worth it for the creditor to chase you down, even to get a small wage garnishment action against you. Rule of thumb, I've always said, is about $3,000. More than $3,000, it might be worth their time to chase you down, get a wage garnishment instituted, and try to collect from you. Under $3,000, just the economics of it. And this is why. West Virginia, Ohio and Kentucky are the same rule. But in West Virginia, you get to keep the greater of 80% of all of your take-home pay, or 50 times federal minimum wage every week. And that's like $360. So if you make less than $360, and if you're working part-time, you're probably not making more than $360. So you've got ways you can fight them. You've got ways you can fight them on this. Now, this is fun too. We have some fun consumer protection statutes out there. And I'm going to talk about two. The federal Fair Debt Collection Practices Act statute, and then in West Virginia, the state Consumer Credit and Protection Act statute. You can turn a debt into an asset. You can take that money that you owe this creditor, and if they mess up under either of these statutes, now all of a sudden you've got the right to sue them for consumer protection violations. How does that work? Well, let's talk about the FDCPA. Protection against harassment, abuse, unfair practices by debt collectors engaged in non-judicial debt collection. So these are things like the, annoying phone calls in the middle of the night, phone calls to your employer. That's a prohibited practice. Letters, angry, threatening letters. They can't cuss you out on the phone. They can't I say litigation threat. Litigation, they can probably threaten, now that I think about it, if they use the right language. They can't threaten to throw you in jail, though. You'll see that every now and then. You can be prosecuted for your failure to respond. No, you can't. Hate grams. It's an affectionate little term. These kinds of things are considered abusive practices by debt collectors. Okay, and so if you start getting these types of collection notices, you need to talk to an attorney, not about a bankruptcy, but about a Fair Debt Collection Practices Act violation. Now, here's a fun one too. If you tell the debt collector to stop calling you, they have to stop. Really? Yes. Well, what do they do then? How do they get their money? They sue you. So is a lawsuit better than them calling you? Maybe. Maybe. Here's the catch here, though. This is the downside of the federal statute. It applies to debt collectors. And a debt collector under the federal statute is only somebody collecting the debt owed to a third party. If the debt collector's attempting to collect a debt owed to them, they're not subject to the FDCPA. So if it's the credit card company contacting you directly for the money you owe the credit card company, the FDCPA does not apply. But if they've hired, some third-party debt collection company, then it would apply to the debt collector. We had a call center here in Huntington. That's what people did. You guys remember that? Anybody remember that?
Applied cards.
Was it Applied Card?
I think that's what.
Yeah. I remember when I was in high school, which was way too long ago. Like that was the job everybody in high school wanted to get because they paid like $10 an hour. And he's like, yeah, you get to harass people on the phone. Yeah. Now I'm like, wish I'd known that 20 years ago. But anyway. So that takes us to the West Virginia Consumer Credit and Protection Act. This is a very comprehensive consumer protection statute. We could spend all day just talking about this statute. It's got a lot of different things in it. A lot. We're only going to touch just briefly here on the debt collection rules. Because like the Fair Debt Collection Practices Act, it prohibits deceptive, harassing, abusive debt collection practices, okay? You can't do the phone calls, the middle of the night phone calls. You can't do the hate grams, cussing people out, threatening to send them to jail. You can't do that under the Consumer Protection Act. But unlike the Fair Debt Collection Practices Act, this does apply to companies collecting their own debts, so long as it's a quote-unquote consumer loan. So if it's a credit card, that's a consumer loan. Medical bills usually are not consumer loans, but credit card companies, mortgage companies, auto finance companies, those are all consumer loans. What this means, though, is that we can set a trap for creditors. How? How do we set the trap? Here's how. Let's say an out-of-state credit card company calls a West Virginia resident about a past due bill and doesn't know about the West Virginia Consumer and Credit Protection Act. Because, they've been trained. Again, you got high school kids making $10 an hour. They don't care. They know about the Fair Debt Collection Practices Act. They don't know about the West Virginia law. This upsets our West Virginia resident. So the West Virginia resident calls a bankruptcy attorney. But this bankruptcy attorney is smart. This bankruptcy attorney sees an opportunity. And the attorney sends the credit card company a notice saying, hey, I have been retained by this individual with regards to the collection of this debt. Cease contact with them. All your contact should be with me. Okay? Now, the credit card company is thinking, well, screw that. I'm not subject to the Fair Debt Collection Practices Act. I can keep calling them. I'm collecting my own bill. Not knowing that the West Virginia Consumer Credit Protection Act actually prohibits that. The West Virginia Consumer Credit Protection Act says you're collecting a consumer loan. You have to stop if you're asked to stop. So, attorney then gives debtor, West Virginia resident, a caller ID box. Says, hook this up to your phone. Figure out what the number is that the debt collector, the credit card company, is calling you from. And every time you see that number pop up on your caller ID, every time the phone rings, write it down in a log. And we're going to let this go on for a month. And we're getting 4 or 5 phone calls a day. Quick math, 30 days, 4 phone calls a day, 120 phone calls, right? Every single one of those, every single time the phone rings, it's a violation of the West Virginia Consumer Credit Protection Act. So what? You can now sue them for statutory damages, and you know how much that is? It actually used to be a whole lot more than this. Still, $1,000 per violation. So that $5,000 credit bill you couldn't pay the company, the credit card company, has just turned into a $120,000 lawsuit against the credit card company. There are attorneys in the state of West Virginia who have made millions of dollars doing that. Suing credit card companies on behalf of, I'm not one of them. I missed out on that train because they're getting a little bit smarter now. That actually used to be about $4,800 per violation. It was $1,000 under the statute, but that was $1,000 in 1974, and inflation had inflated that number up to about $4,800. So you could hit your number in about 5 days instead of 30 days. Let it go for a week.
Is there a limit to the number of violations?
Cap on damages is $175,000 under the new statute. This new statute's 2015. But yeah, it's still fun. Still a lot of fun. Here's another one I get. Why don't I just transfer my assets to my family? My brother over here, I'm just going to put my car in his name, and I'll put my home in my dad's name, and none of those SOBs, credit card companies, can sue me and get anything from it. Why not just do that?
It'll mess up your family's credit.
Well, no. I mean, if it's unsecured debt, the assets are nowhere tied to the debt itself. No, the problem with it is it's fraud. It's literally called a fraudulent transfer or a fraudulent conveyance. If you don't receive reasonable value in exchange for the asset that you transfer out. So you can sell it, but you can't give it away. Or you can't sell it way below market value. If you don't get reasonable value for it, either a bankruptcy trustee can sue to reverse it. So now they've sued your family member to get that asset back. So yeah, it can screw up your family credit, right? Because now you got a lawsuit against you. or even outside of bankruptcy. Outside of bankruptcy, creditors can sue your family member. I have consumers come to me and say, well, why don't I just, yeah, I was thinking about doing this. Why don't I just do it? Well, because if you want to get your family sued, go right ahead. I'm not going to advise that. Do it if you don't like your family members. How about that? Mend fences with your estranged cousin and give him the car and then file bankruptcy. That'd be fun. Thanksgiving next year would be fun. But anyway, again, you can sell it. You can sell it so long as it's reasonably equivalent value, that's fine. But you still might get a lawsuit because those are going to be highly scrutinized. And if it's questionable whether or not you got reasonably equivalent value, probably going to get your family member sued. And that's not good. We don't want that. All right, so to kind of wrap this all up, I know we said that one of our goals here is a fresh start, but it's really not a fresh start. Bankruptcy isn't really a fresh start. It's more like a nuclear bomb. There's fallout. It kills your credit. It kills your relationships. It's a huge stressor. And if you don't actually fix the underlying problem, you're going to be right back in the same shape. Okay? So, if you're having, where am I at my notes? If you are considering bankruptcy, that's the last thing you want to consider. We don't open up dropping nuclear bombs. That's our last resort. Go talk to an attorney and make sure that attorney discusses options and consequences with you. Again, I laid out 3 questions there. What are your goals? What was the other question? Will the bankruptcy actually help? Right? Will bankruptcy make it worse? Are there non-bankruptcy options that can solve your problem? Or at least give you that relief you need until you can solve your problem. If your bankruptcy attorney isn't discussing those things with you, you need to find another bankruptcy attorney. And again, don't expect all those financial problems to disappear. This insolvency thing, cash flow insolvency or balance sheet insolvency, it's not usually something that happens overnight. Sometimes it does. Sometimes we have traumatic situations that happen. Car accidents, lost jobs out of nowhere, that causes problems. Those are the folks who bankruptcy really can help, assuming the numbers make sense. But if you have poor financial decision making, if you don't know how to put a budget together, bankruptcy isn't going to solve your problem because you're going to be right back in the same position you were in when you filed eventually. That's one of the reasons we have this CCLE here on campus now. And Damien can talk about that way more than I can, but about the financial literacy rates in West Virginia. About just the basic struggles that people have putting together those budgets. And not making your budget, but literally understanding what needs to go into just drafting the document itself. So I will say in conclusion, pay attention to what we've got going on here with the CCLE, the Center for Consumer Law and Education. There's going to be a lot more happening here, a lot more resources for our consumers to make sure that bankruptcy isn't the only option out there for them. So with that, I'll open the floor to any questions. Open the floor to Damien if he's got any specific programs he wants to talk about.
Yeah, we'll leave it for questions and then I'll talk
Okay.
a little bit about that.
Do you get to pick your trustee?
No.
They seem pretty important.
Yes, they are very important. They are all court appointed. So the court decides it's supposed to be at random. I don't know that it is at random. Got some conspiracy theories if you want to go down that route, but since we're being recorded, I probably shouldn't go down that route. But no, you don't get to pick your trustee. There's a panel. There's half a dozen or so in every federal judicial district. And actually in the bigger judicial district, like Southern District in New York, they're going to have more than half a dozen. West Virginia, I want to say there's 4 or 5. Southern West Virginia. Anything else? Yes.
Yeah, does the CCLE have an office here on campus?
Yes.
We do.
Okay.
Just email me.
Is it
I don't think it would.
contact, maybe?
Well, yeah, we're in the process of getting this
Oh, okay.
physical. I said just email me, but, you know, we have the opposite problem of other places wherein we have an idea, we try to build it, you know, we have a lot of money contracted. So, we're in the process of getting that physical space.
That's such a terrible problem to have, too.
I know, right? It's really obnoxious to say it out loud. But I mean, you look at a place like the University of Houston Law School, they had a center like this for a long time. In addition to kind of their educational component that they did, they also did clinical work as well. And it's really the brainchild of one professor there who built it up from the ground, from nothing until what it was doing. And unfortunately, I think it's going to go away when he leaves, but they had to build all of that capacity from the ground up. And so we're doing some of that, but
And that's,
we
yeah.
had someone with a vision who's like, this is what I want. And, you know,
And that's one of the problems with us not having a law school. If we had a law school, and, you know, we're named after the greatest Supreme Court justice, and we don't have a law school, figure that out.
yeah.
Usually in states will allow law students to take on those types of consumer protection type, consumer advocacy type cases where these folks aren't going to be able to find a lawyer. Now they have to do it under the supervision of usually a faculty member. But you can get help for consumers that they wouldn't otherwise be able to get. Actual advocacy, courtroom advocacy.
And we've talked about this with our partner at WVU College of Law. So in the meantime, the plan is to try to partner with legal aid
Yes.
to handle some of this when it does arise. Any other questions about this topic?
Thanks for coming. Thanks for braving the monsoon. Remind my students, make sure you sign up. But know you're here.
Let me show you a little bit about some of the opportunities that we have. One, he mentioned the financial literacy. This is going to be a major component of what we're trying to do. One, we're partnering with the Consumer Financial Protection Bureau to do some of this financial literacy in the state of West Virginia. We don't actually know all this information about what's transpiring and our lack of financial literacy in the state. So we hope to try and do that as a research project. We have some other ideas about research. How much do these consumer types of cases cost? We need that type of information. So if you're interested, both if you're faculty and or if you are a student, you can go to our website and click students and scholarships. We do have some of these awards that are available currently for you to apply for. You can click the application if you want. More about the award here. Basically, this broadly defined in the sense, if you have an idea that's related to consumer in any way, we're interested in hearing about it. And so just stop and ask yourself how your life is not impacted by being a consumer. I think you'll be hard pressed to come up with any aspect of your life that it doesn't revolve around you being a consumer, from I mean, what you eat, what you buy, education, I mean, where you are, I mean, everything is related to being a consumer. So, I mean, if you had an idea about a project like, I don't know, I mean, literally anything that's interesting, that advances the mission of the center, we would be interested in hearing that. And so what that award would primarily do is provide you anywhere from, we have $2,000 total to give out, so apply and we can discuss that if you were interested, okay? It could be a survey where you ask college students their financial literacy rates or what they know about this aspect of financial literacy. It could be, asking students what they know about the promissory notes that they're signing in order to go to college. I mean, whatever that sparks your interest.
Raise your hand if you actually read your student loan agreement. I didn't read my mortgage either, so that's fine.
Yeah, no, just sign. Give me. So yeah, that's one of those. And again, I know we have some faculty here, and I'll plug again that we have some for faculty. The application as well. We have 2 different ones of these for faculty. So if you're interested in that, we have a much larger award that has different responsibilities than the Faculty Opportunity Award. But check out our website. We've got some pretty cool stuff up there now. We've done quite a bit of research in terms of policy reports that exist on financial aid. There's a ton of stuff there. You can link out to it, and you can search by topic that you're interested in if you want to learn more about it. So we have peer-reviewed stuff. Legal research isn't quite updated yet because we're still trying to get that from the law school, but the policy reports and peer review is pretty up to date. We have the YouTube channel, which this video will go up on soon, and quite a bit, blog, whatever, because that's what people do now, are blogs, right? But anyway.
It needs to be a blog, BLAW.
That's right, like a law, yeah. The other thing we have is we've contracted with, what is it called, Anthony? InfoCision. InfoCision is a proprietary RSS feed that will basically search the world and provide us with updated contact or relevant consumer information every single day. So that will be integrated to the website very soon. Any questions? Life, liberty? All right. Thank you so much for coming out. We really appreciate it. Skip in case you know. I guess they stopped recording then. Okay.
Cut.
It's over. Pretty good turnout.
Yeah.
Thank you, guys.
Thank you.
Thanks for coming.